Okay, well today's a very special day for me. I'm going to court. I've been summoned to go to court. So I'm a bit concerned about what my involvement's going to be. I've got this very official letter from the government that's summoning me in very stern, autocratic kind of language. Look at this. I'll just block out my address. Summons to a juror. I'm going to be a juror at the Supreme Court. You have been selected for jury duty and are required to be available to attend the Supreme Court at Brisbane for a period of 3 weeks commencing 3rd of June today. Supreme Court. So that could be something really serious, Meryl, couldn't it?
Sure.
Okay, so I've got my long pants on. I might even put some socks on today if it's going to be the Supreme Court. I don't normally wear socks. Do you think I should put socks on?
Sure.
What else do I need? I need to make sure that I'm presentable. So
really? That's the criteria. Presentable.
So I'll take my brush so that I can brush my hair if it gets out of control. This is my headband for squash. Maybe the proceedings will get so tense that I'll break out into a sweat and I'll need to put the headband on to stop the sweat falling in my eyes, just like in squash.
I'm thinking, no.
Maybe I should just wear it straight in so that they know I'm serious about it.
I think that would get you a exit to the door. Exit stage left.
Okay, no headband. Alright, so I don't know, I'm guessing I'm probably not going to be able to film the proceedings at the Supreme Court.
No, definitely not. In fact, you may not even be able to take the camera.
Well, I have my phone and the phone's got a camera in it.
Maybe not.
Well, we'll see. Anyway, I guess I will be able to talk about whatever's happened after it's
Only to selection. You won't be able to talk about any
I can
case.
talk to the viewer about it.
No.
After it's all over.
Yes.
So after the murderer has been convicted and is safely in jail, then I'll be able to talk about what happened, right? So
I'm not sure.
I think you can. I think after it's all over, all bets are off. Anyway, that's what's happening today. So I'll keep everybody informed. I'll let you know how it goes. Probably a bit later than as the events occur, as I say, for those reasons. So wish me luck, Meryl.
Good luck.
Okay. Okay, so here I am at the Supreme Court. Doesn't look very supreme. I suppose at 415 George Street, it doesn't even have a sign saying Supreme Court. Well, I guess it's the right place. It's just before people are allowed in, so I guess there's a whole lot of, people who might be defendants or witnesses or jurors like me all standing out the front waiting for their chance to go inside and do their thing. I wonder if we can pick who's here for what. I would say the people in the suits, like there's a couple of people in suits, they'd have to be the defendants, wouldn't they? Because they'd be, they would have hosed themselves down and spruced themselves up to try and pretend that they're respectable people for the day. The casual looking ones, witnesses maybe, other jurors like me, hard to know. They got a massive security in the front there. I don't know if I can zoom in. There's about 5 people in there who are, looking very serious and look like they'd be able to crash tackle just about anybody. So I'll be going in a minute and then I'll give you my report at our morning tea break or lunch break, I guess. Okay, guess what? I'm not allowed to film anything inside the courtroom, but I guess that's no big surprise. All cameras not allowed, phones aren't allowed, got to lock it all away. So you're not going to see anything of me inside the court and the process involved there. But I will tell you about what happened and some of the interesting things that did occur. All right, just to quickly take you through the process for any of you that haven't been there, you go in initially because your number's been called on a ballot. And there's about 120 people sitting down, and they randomly apparently call out 30 names out of the 120 in a big room. We're all sitting around. And the first round of 30, not me. Second round of 30, 36 actually, was me. So then they cart you off through this very convoluted route into the actual courtroom for the first session. And you're sitting up at the back of the court with all of the key players sitting in place. Now, the judge reads out the charges to the accused and then says to the prosecution and the defence that you need to decide whether or not you like the idea of any particular juror. So then there's another ballot, a little barrel going around, and your number and name is called out again. And the idea is that of the 36 people that are sitting up the back of the room, they're going to pick 12 people from it. And each of the side, the prosecution and the defence, are able to challenge, which means reject. I think they're allowed to do 3 or 4 each or something. That's the maximum they're allowed to. They don't know anything about you. That's purely based on the way you look. And the way the system is supposed to work is that you get up from behind all of these players that are sitting down and walk across the room in front of them. They have a look at you. If for some reason they think that you're not going to be useful to their cause, I don't know on what basis they make that choice, but they don't have to say why. They say challenge, and then you go and sit down again. If they don't say challenge, you go across to the witness, to the jury area, and you're sworn in, and you sit down and you're ready to go. Now, what was interesting about that was that, as I say, they're supposed to look at you as you're walking past them, but takes I don't know, you maybe 20 or 30 paces away from where you get up out of your seat and then you're standing in front of them. But in all cases but one, and there were probably about 7 or 8 challenges in total on some on each side. The challenges occurred within about 2 seconds of the name being called out. In other words, let's say it was me that was being challenged. They'd say number 20, Don McGregor. You'd say yes, present. You stand up and start to move out of your seat. And the two sides just turn around and look behind them because you're sitting behind them. They take a look at you, and then that's when they almost always go, challenge. So you've only maybe taken 2 steps. You haven't walked out. You haven't presented yourself in front of them in any way. They've just looked at you from across the room. You've stood up, and they've decided that they don't like the look of you. Now, they did tell us that don't take the challenges serious, personally. They have all sorts of crazy reasons that they don't have to explain as to why you might be challenged. But the thing is, it is personal. It's nothing else. What else can it be? They look at you and say, I don't like the look of you, and I think that you're not going to be saying the sort of things that are going to support my position. And so it's 100% personal. And so the other interesting thing was there was actually a pattern to the people that were being challenged. It wasn't a random thing at all. That pattern, and I think this is a sad indictment on our society, was basically the way people looked. Nearly all of the first guy that was challenged, he was a fellow that was a bit disabled, slightly cerebral palsy, I think. He had a walking stick. We had a bit of a chat before we all went in there. He seemed like a fine, nice guy. But as soon as he stood up and they saw that he had a walking stick and he had a bit of a strange walk, challenge. Now, why that would have anything to do with being someone supportive or non-supportive of your case, I have got no idea. The other people that were challenged were almost all overweight people, big people, would stand up and make one or two challenge straight away. Again, overweight, got nothing at all to do with whether or not it's going to be useful as far as I can tell. Dark skin, there was a dark skinned guy, challenge straight away. So they say it's a totally random thing, but it seems to me that it's just based on the normal prejudices that we all have. So what we ended up with, I wasn't challenged. I just sort of fit into the normal sort of average kind of looking person, I suppose. And so all the people that ended up in the jury were just average looking people with nothing sort of out of the ordinary about them. So then off we go. So I can't talk about the actual details of the case. That's not important anyway. But the first thing that I noticed about the setting was how formal and sort of staid and bureaucratic and stuffy the whole environment was. No pleasantries, no sort of pleases, thank yous, how's your day, or anything like that. Everyone is absolutely stony-faced, almost expressionless. These are all the players, the judge, defence, and the prosecutors and their offsiders. Everyone is just stony-faced, just staring ahead with no emotion or anything. Obviously, that's got something to do with not wanting to show bias or I don't know what it's got to do with, to be honest. And then there's the robes that they wear. They've got the wigs and well, it seems to be optional. One side they had the full gown and wig. The judge actually had the gown but not the wig. One of them had the wig on the table but not on the head. So it seems to be up to them, or maybe the company that they work for, that determines what they must and mustn't wear. But it's always seemed really sort of strange to me, all these wigs and gowns and things, which were the order of the day, maybe in sort of 1750. That's the way everybody that was rich or had a position of power pounced around in those wigs and gowns and things. But and they try, but the judicial system, this is what's weird to me, they try to tell us that they're in touch with the community, that they represent, contemporary community values, that, they're like the man in the street, that's what they're there to represent. Well, sorry, but the way you looks like a contemporary person, a man in the street, but a man in the street from the 18th century, from 1750. Hello, they don't look like that anymore. So if you want to present yourself as a current contemporary thinking person, don't dress like someone that's 300 years old. Anyway, that's just me. Maybe I'm being unfair there. Anyway, so off we go. The whole process is followed through. All the prosecution puts their case, the defence puts their case, and then off we go for our jury deliberation. So they take us off into the deliberation room. Now, every time we're allowed to leave, you're allowed to, but they lock up your phones and you've got to leave any documentation. But they do let you actually go out for lunch, and you can sort of behave like a normal person. Can't talk to anybody, cone of silence. They let you go home. Don't say anything to anybody. If you say anything about the case, maximum 2 years imprisonment. I kind of get why that is. They don't want anybody getting their ideas from anywhere other than what's being presented in the court. I kind of understand that, but it is. They are very sort of finicky and strict about it, even to the extent that they don't want us to be influenced or possibly influenced by anybody that we see in the court area. Somebody that might be someone that's come to visit that might be on the side of one side or the other. You might run into them in the lift or whatever. So to try and avoid that happening, they have this really complicated, convoluted route that you need to take. So when you leave for lunch, for example, we're up on a given floor of the building. You just go. Supposedly, you can just go straight down to the bottom and out the front door. But oh no, we can't do that because we might run into somebody that we shouldn't run into. So they cart you off into this strange little area, put you in this funny little sort of lift that's not related to the normal lift system, down to one level, around through a whole lot of little rooms and corridors and into another lift system, down again into another sort of area, behind the scenes area, around through tables and chairs and things, and then finally through the last lift system you get to be on the ground floor and you come out through a little side door. So this is so that there's just no way to come in contact with anyone. Now, despite all of that, a couple of the jurors actually said that they saw the accused person wandering around. They nearly made eye contact with them getting on or off the train somewhere. So despite their best efforts, it's still possible. No contact was made and nothing was said, and they deliberately avoid them. But what can you do? If everyone's walking around the city, it could happen. So anyway, so off we go. We go through our deliberation. Now that was actually quite an interesting process. Our case was pretty straightforward in our minds. We all, when we had a bit of a poll as to how we thought, we were all pretty much thinking the same way, and that was that the events occurred the way the prosecution described it. In other words, the person who was accused did what the prosecution said and was therefore going to be guilty. Now,
the only, well, there were two sort of possible complicating factors. Again, no mention of what the case was about, but this would occur in any case, I'm sure. One was whether or not we thought, even though we thought that these events had occurred and that the person had committed the offence, it's the beyond reasonable doubt thing. So there were doubts involved, obviously. Now the question is, we have to resolve in our mind is, was the doubt enough to constitute reasonable doubt? And if you say to yourself, yes, I think there was reasonable doubt, well, then you have to say not guilty or acquit. And the other side of it is looking at that reasonable doubt issue. When the defence makes their claim, they say that quite rightly in this case, is again in all court cases, that the onus is not on the accused person to prove that they're innocent. We have to start with a presumption of innocence, and the onus of proof is on the prosecution to prove that they did actually commit the offence. So it's all about whether or not we believe that their case has been proved. Now, proof is an interesting word. It means different things to different people. And so I and a couple of other people actually were concerned that what does this actually mean? Does that mean if we sit and listen to all the evidence and we're quite satisfied, for example, or convinced that this crime, whatever this crime is, occurred, but we're just not comfortable that there was actual hard proof offered to prove that, or corroborating evidence, or physical evidence and things that would actually be proof, even though we were quite convinced. Does that mean that we have to find that this person is not guilty just because there isn't hard evidence, even though it's clearly obvious to us that this offence occurred? So that was troubling to me and to a couple of other people. So I actually put a question to the judge based on that. You're allowed to, if you've got a question about the process or anything along those lines, you can submit that question via the bailiff, who's the official person that links us to the court process, and you write it out on a bit of paper, question to the judge, and then the judge looks at it, brings us all in, and then reads out our question and then answers the question. And it was my question was purely and simply to do with the difference between being convinced or satisfied that a case has been proven and it actually having been proven beyond reasonable doubt with hard evidence, corroborating stories and physical evidence. Is that a requirement? Because in my mind, that was a much higher level required than just believing and being convinced that this occurred. And I asked her to clarify that. And if it was the second thing that required proof, I wanted actual clarification from the court as to what that defined, what was that defined of, as in the legal context. So anyway, so she reads this out, and that worried me because, as I say, we were all pretty much on board that these offences occurred, but we were all very much concerned that there was not a lot of actually hard corroborative proof. And so depending on how that question was answered, it could make like the complete opposite result from the jury. So anyway, she answered it in a way that was, thank God, I was so pleased. She said, there's really, as far as the court's concerned, there's really not a big difference between being convinced and being satisfied that something occurred and it being proven. It's up to you in your individual way of thinking as to if what you've seen and heard, if you're convinced that this proves that this occurred, then that's up to you to make that decision. There's no hard and fast rules about it. So it's a individual thing. Now that was a big relief to me because that meant that it made it a lot clearer, despite the fact that there was very little actual corroborating evidence. I was very satisfied in my mind that these events occurred, and therefore I could say that this was proved. So that made the process from then on a lot easier for me and probably a few of the others as well. And so we then went through the whole process, and to cut a long story short, we all, at the end, there were six charges against this person, very serious charges. We're talking about crimes that involve potentially, many years imprisonment. So these aren't light charges. A big impact on the accused, and of course a big impact on the victim too, depending on which way it goes. Massive impact. So I had to be very clear about it. Anyway, fortunately, we were all very clear. It was all unanimous in the end. There were a few people who had some concerns along the way about whether or not they were totally convinced beyond reasonable doubt, because there were obviously a few things that sort of muddied the waters and complicated things, dates and times that didn't match up, that sort of thing. But we were able to establish that even though there were a few concerns and queries, they didn't really amount to, stopping us thinking that this event occurred beyond reasonable doubt. So because it didn't tip that threshold, we were good. All convinced, went in, we all said yes, we're all in agreement that all the 6 counts are proven. And then, of course, the accused looked very unhappy about that. He'd just been sitting stony face through the whole thing, but he wasn't impressed with that, as you'd expect. And then we all had to leave, and we were told by the bailiff that the sentencing was going to occur straight away, which was good news to us because we all would be very interested to see what the sentencing would be. So they took us out of our little secluded jury area, around a few more convoluted corridors, and went straight back into the same courtroom, sat up the back, and were there basically as an observer. Anybody can go to these courts, by the way, and observe these sittings anytime. This was the Supreme Court, High Court, because it was a very serious case. And we thought that some of the players involved might have been sitting in the area at the back as well. Some of the witnesses and people that had been talked about in the case had turned up to hear the sentencing. Anyway, the sentencing was carried out. I don't know if I'm allowed to say what it was. It doesn't matter. It was a high number of years that this person was sentenced to, which is quite appropriate. In fact, I would have been even happy to see double the number of years imprisonment given to this person, but it was adequate, I guess. And so, of course, off they go, handcuffs on, out the side door. So it was a very interesting thing. At the end of it all, we all sat down and said, well, how do we, because we get to go back and collect our phones and belongings and all the notes and everything that we've made are all gathered together, and they're all going to be, destroyed. And, the cone of silence kind of comes off then, although they did say it wasn't a good idea even after it's all over to talk about the case, which is why I'm not giving you any details of the case. But we all talked about how we felt. And I felt very relieved, extremely relieved. To me, it was sort of elation, not so much because I wanted to see the accused have a long time in prison, but more because it was so important to me that the victim was vindicated, that they were shown by the system to be believed, that yes, it was worth all the trouble and trauma they went to state their claim, and that they were vindicated. And we were very lucky. We had an interesting bunch. There wasn't much conflict. We had a great speaker leading us through it all. They used to call the speaker the foreman, but apparently that's politically incorrect now, because foreman, of course, gender specific. So we're now talking about a speaker, which is gender neutral. But it could have been a lot more chaotic, but he obviously had plenty of experience running meetings and things, I guess, and he guided us down a very logical path and made sure that everyone was heard. I was very annoying lots of times, I'm sure, and he was able to not get upset with my annoying interjections and procedural questions and things, and got us through, and was very gentle with us. We had some other great people there. There was all different personalities, people that were very into detail, which was great. They documented all the times and dates that had been listed. Didn't have much detail because right from the beginning I was quite satisfied with the case, and I didn't really care if some of the details weren't quite right. I was convinced that these things occurred, but others wanted to get into the details, so someone was documenting that really well, which was great. We had a great scribe, someone with nice neat handwriting, that because we we had a whiteboard, filled up the whiteboard, needed 2 other big butcher's paper pages of notes, with blue tack sticking all around the wall, and we had to work through it all. So you need someone that can, put the information up there clearly that we can all read. So that all worked well. Lots of different personalities. There were about 3 other people in my age group. One guy had some kind of, traumatic problems in his past, so he was able to relate on a personal level to a lot of the things that happened, which was interesting. We had a young person there that was giving us all the tips on, what happened, the implications of social media and phones and how that all impacts on, because that did sort of play a part in a way in terms of what we were looking at. So for those of us that are a bit out of touch with what, young people and social media are up to, we had that input too. And yeah, so there were a lot of different characters in the room, and it was a great mix. Everyone was very supportive of everybody else, and that really helped a lot. If there'd been some problems there, I'm sure that would have not helped. And our bailiff was good. It was a German woman. Yeah, great bailiff, lots of fun. Unlike the actual people in the court areas, very friendly. How was your lunch? What'd you get up to last night? But as soon as you hit the courtroom, it's like not, welcome back from lunch, ladies and gentlemen. How was your lunch? Or, have a good night, or see you tomorrow. None of that. Stony faced, right, you're now dismissed. Now you're back. It's so formal. So yeah, thanks to all those people. If you're listening to this, you'll know who I'm talking about. Made for a really good process. So there we are. So we're finally let go. Cone of silence comes off, sort of, and we're back to real life. It was a very interesting experience. So just a final thought about that whole process and what it actually means. May or may not have anything to do with the case. This would apply outside of my experience, but it's just the whole process has highlighted something really important to me. And that is that, for example, in the case of sexual assault on people, particularly something like, say, rape of a child under 12 by a mature person, that victim in that case has been through absolute nightmare experiences where people may well have disbelieved what they were saying, and they finally get to the point where they've got the courage to speak up and try and A, stop the situation happening to them or someone else, and B, bring about some accountability on behalf of the perpetrator. It's so important that we support these people. Apparently, of all the cases like that are brought to the attention of courts, someone's been brave enough to actually go to the police, make a complaint, which again is a very small subset of the actual cases that occur. And then, those get through the system, and those cases then find their way into the judicial system. Only 1 out of every 100 of those cases leads to a conviction. There's a whole range of reasons, I suppose. People bail out along the way, deals are made. But more often than not, it's because it's a he said, she said situation where there's just not enough hard evidence to, unlike a lot of other kind of cases, there's no other people involved other than those two. And so what you very sadly end up with is a victim that appears to be let down by the system, where to all people around them it looks like, well, basically they weren't telling the truth, when actually all that happened was that the legal system wasn't able to cope with the fact that there wasn't enough hard evidence to get people into that beyond reasonable doubt area. So it doesn't happen very often when it does happen, but it's absolutely fabulous when it does. We need a system that's going to allow for that and encourage that if we're ever going to make a change in these areas. And we need good, solid punishments for perpetrators involved, so it sends a very clear message to the world. Not saying that that's what happened in my case. This is a general statement, but it did bring it very much to the front of my mind, the situation and the plight of the victims. So anyway, that was a bit more serious than a lot of the videos we do, and it was a lot longer too, so I'm sorry about that, but it just seemed like trying to cut that down to 5 or 10 minutes just wasn't doable. So for those of you that have hung in there to the end, thanks very much, and we'll go back to the nice, sharp, light-hearted, silly, sometimes videos from here on in, and thanks for hanging in there.